We have just a couple of minutes remaining, but I do want to get just your final thoughts, maybe a key takeaway for our attendees from each of you in about 20 to 30 seconds, if we can do that each, just those thoughts you want our attendees to walk away from the presentation with. Marissa, we'll start with you.
Sure. I mean, I think my final thought is that this should definitely be a company priority, even when you're sticking with labels that seemingly comply to the regulations. A lot of the regulations are just so ambiguous that plaintiffs' attorneys, they have sort of enterprises now that they'll actually troll food aisles at supermarkets. And they're on the record saying that that's what they're doing, looking for even technical violations. So it really needs to be a company priority. And to the extent that you can get, if you're going to hire outside law firms, to the extent that you can have an outside law firm that has both a regulatory and class action practice, I would say is even better, because it can all be in-house. It can help you sort of do that efficiently. Or if you're a bigger organization, you sort of have that capability in-house. That's important to make a priority, and you should make it a priority early on.
Okay, wonderful. Thank you so much, Megan.
Thank you. I think I would say, just kind of tagging on to the point that the food court seems to be here to stay, agreed, it should be a company priority to focus on these things, keep up on the law, keep up on the evolution of the litigation and the claims. While there are defenses at varying stages of the litigation, whether, at the pleading stage or summary judgment or class certification, it's still probably in the best interest of the companies of these products to take a hard look at things before they get to any of that. So definitely keep it a priority.
Wonderful. Thank you so much. Christopher?
Yes, hi. So I've tried consumer deception cases before juries. They don't like these claims. And I would encourage companies to consider pushing back and fighting them hard. It's difficult to get a class. It's difficult to convince a jury that, in fact, there's any merit to these claims. The Palm v. Coke case was the huge win for Palm in the Supreme Court. They lost before a jury. And I think these settlements are way too high, and they're building war chests. And for this ever to stop, I think companies need to really dig in and fight hard to the extent they can.
Wonderful. Thank you so much. And finally, J. Lee Gray.
Yes, I would follow what Christopher just said. I do think that companies are basically being shaken down and giving in a lot. I know I receive a lot of these demand letters from my clients lately. Have been geared towards the technical or quote unlawful violations that Marissa mentioned a few moments ago, and I think that they should stand their ground. But before you do that, you should act responsibly as a good, responsible manufacturer, and be knowledgeable about your labels and the potential dangers that they have. And the only thing I would add is you should also be keeping an eye on what kind of information you're getting back from customer service, and be ready for recalls if those are necessary as well. We didn't talk about that in this, but food recalls are also a very large area of this whole food law realm.